trust in structured finance, particularly when there are multiple lenders involved?
All right, thank you very much, Arias. Let me start first with a brief description on the concept of the venture trust. So it is a structure, simply a structure where a company, especially companies who are into businesses that require working capital and so these people typically would need to raise capital either from a group of investors or lenders, whilst also leveraging on the assets that the company in its legal interest owns. So these assets in a debenture arrangement are moved into the trust under the custody of the trustee as a form of security or collateral to secure the borrowings from the lenders or the investors, as the case may be. So, for proper structuring, the trustee would usually take ownership, that's legal ownership of the secured and the venture assets by placing the charge on this asset until the borrower, that the company, fulfills its obligations to the investors. So the venture trust aids a borrower's ability to, ensure that they are able to access multiple facilities from different financial institutions at the same time. And it also allows the company to maximize its assets as well as kind of reduce wastage of the value of this asset. So let me give a typical example. So say company Z PLC, which is let's play with this scenario, a manufacturing company. This company has decided to obtain facilities from multiple lenders at the same time. So, in doing this, they would be leveraging on the value of the same collateral. So, in a situation where they've gone to commercial bank A and commercial bank B, commercial bank B would not be comfortable with commercial Bank A holding the assets in its custody because commercial bank A also has its own interest. So a debenture trust will be structured in such a way that the assets are pulled into the trust for the benefits of both commercial bank A and commercial bank B. So the loans and the facilities are usually secured by the company's assets that have been transferred to the trustee by way of a security trust structure.
Thank you very much, Vivian, for that very detailed explanation of what a debenture trust is all about. I'm sure we still have their follow-up um, answers to that as well. So I have another question for you. What is the role of a trustee in such an arrangement? Because we understand that Merisem Trustees Limited plays that kind of role in the industry. So can you tell us what is the role of a trustee in such an arrangement?
All right, thank you, Ariel. So, a trustee in this sort of arrangement typically, for a lack of better word, acts as a middleman between the borrowing entity and the lenders or investors, as the case may be. So, the trustee's major role is to protect the interests of the investors and the lenders, making sure that the borrower sticks to terms of the security documents and loan agreements. So, on a periodic basis, the trustee ensures that it monitors the lender's interest in comparison with the assets that are held in its custody as collateral. So, this is to ensure that borrowings do not exceed the for sale value of the assets held under trust. The role of the trustee is also to ensure that when there is an event of default, it is able to, enforce the security to take care of the borrower's obligations to the lenders.
Once again, thank you very much for that detailed explanation, Vivian. I have one more question before we move over to Adekunle.
Okay.
Um, how does a debenture trust, how does it simplify the relationship between these multiple lenders? Because you've talked about multiple lenders, multiple borrowers. How does a debenture trust, how does it simplify the relationship between these multiple lenders and the borrower?
Okay, thank you, Aaron. So the debenture trust simplifies the relationship between the lenders and the borrower by more or less centralizing the management of the collateral and creating like a one point or single point of reference for all the security assets or secured assets against the borrowing with these lenders. So all of the decisions that are typically made in relation to the borrower's obligations to the lenders are centralized. The lenders don't need to act on their own when they need to interface with the borrower with regards to the security. So, an example is in a situation where there is an event of default, the enforcement, that is both the legal and the administrative bits, are tailored in line with the provisions of the security documents. So, in simplifying the relationship, the trustee ensures that both the lender's interest as well as the borrower's residuary interest are managed efficiently. So, without the debenture trust, the multiple lenders in such a situation would typically try to enforce their own claim on their own. They would rather do it independently. But with the trust arrangement, they are aligned in terms of the decisions that are made when it comes to the borrowings and the borrower's obligations to them. So this typically, if the borrowers were acting on their own, it would typically lead to complex legal battles and unnecessary delays. So the structure kind of makes it easy to also, admit new lenders and also exit the lenders who have confirmed to the trustee that the borrower has met its obligations to them or has fulfilled its obligations to them. In all of this, during all of these activities, the trust arrangement itself, the structure remains intact. Nothing changes except in a situation where assets are removed from the trust or added into the trust.
Lovely, jubbly. Thank you very much, Vivian. I mean, I suppose such an arrangement will foster trust between potential financiers, potential lenders, and the borrower, right?
Yes, that's correct.
Okay. Thank you very much for that. I would like to come to you, Adekunle. I would like to get your take on, what are the key legal regulatory considerations and the essential documents that are required to establish a debenture trust?
Thank you so much, Arians. So in terms of key legal considerations, if you look at a venture trust or a security trust, these are typically governed by the common law of trust, right? And the common law of trust is tailored in such a way that creates confidence between, in this situation, the borrower and the lenders in relation to the loan or assets that they have put together amongst themselves. So under the common law of trust, a trust is a legal relationship whereby a person called a settlor places assets or property in the control of a trustee, like merchant trustees, for the benefit of beneficiaries, right? So under the venture trust or security trust arrangement, um, the settlor is the borrower, right? While the lenders are the beneficiaries of the trust assets that are used to secure the loan. So what typically happens is that, like Vivian mentioned, right, the entire trust assets are moved out of the control of the borrower, right, put into the hands and control of the trustee. And this helps to create confidence between the borrower, trustee, and the lender as well, right? So that trust structure and the common law of trust governs that entire trust arrangement. I mean, between the settlor, which is the borrower, the lenders, right, as well as a trustee, right? So that's one, right? The second is the Investment and Securities Act, right? And that's because trusts, business generally, are governed or are regulated by the Securities and Exchange Commission, right? So directions and requirements that are provided, from time to time, by the Securities and Exchange Commission becomes relevant, and becomes applicable, to govern the entire trust arrangement, right? And that's why you need to go to a trustee that is like Merchants trustees that are regulated, are well known, have been tested, right, and can help you create this arrangement that helps you to optimize your assets. Now, when it comes to the assets that are being secured, right? In terms of what governs them, right? If, for instance, if there are fixed assets or floating assets of a company, right, then the Companies and Allied Matters Act will govern that entire process, right? So if you are using fixed or floating assets, that governs it. Then you have to register those assets at the Corporate Affairs Commission as charged assets against the borrower. When it comes to real property or real estate, right, and that I mean land, things like the Land Use Act, right, conveyancing law of the relevant state where property is located come into play. And you would have to register that particular property, right, with.
Hello, Adekunle. We seem to have lost you there. Okay. I think we have you back. One of the problems of network in Nigeria. Adekunle, you're welcome back. I think we
Okay.
lost you for a
My
bit.
apologies. Yeah,
No problem. We're in Nigeria. We understand our climes and how things work.
all right. Thank you so much.
Please do
So,
continue.
so yeah, so like I was saying, when it comes to the assets themselves, right, we need to look at what type of assets are being secured, right? So if they are fixed and floating assets, the Company and Allied Matters Act will govern those assets, right? And once they govern those assets, you will need to register them with the Corporate Affairs Commission. When it comes to land or real property, right, they'll be governed by the Land Use Act and the conveyancing laws of the respective states, where those properties are located, right? And you will need to register those properties at the land registry of the relevant states. Then when it comes to other movable assets, right, there is what is called the Secure Transactions Immovable Assets Act, right, of 2017, right, which creates a collateral registry that will govern those other assets, and they will be registered at the collateral registry. So that, in summary, constitutes what is the legal framework or legal considerations when you're doing a debenture trust, or a security trust. But when you now put that arrangement in place, you also need to put some documentation in place, right? And those includes at least two major ones. One is the security trust deed, which is the legal document that creates the trust itself, right? And you will need a trustee like Mersem trustees to be a trustee that will be independent to regulate the relationship between the borrower and the lender, right? And will hold the assets for the benefit, of the lenders, right? Then the second document is the intercreditor deed, right? And this intercreditor deed sort of like governs the rights of the lenders, particularly in a multi-lender scenario, right? You would need that intercreditor deed to govern the rights of the lenders to receive payment, right? And also determine their priority of distribution of proceeds in the case of enforcement. So those two documents are critical, right? You could either sign them separately or incorporate them into one another, right? But if you consider all that I have said, that will constitute what you can consider as key legal considerations and the legal documentation you need to put in place to create a venture trust or a security trust.
Thank you very much, Adekunle. Very well explained. Thank you very, very much. I'd like to also ask, how does the trust structure address issues of enforceability in the event of default? Because the trust is meant to ensure that all parties are well covered. So how does the trust structure itself, how does it address the issue of enforceability when there are events of default?
So in a situation whereby there's an event of default, right? Because you have a trustee, right? The trustee, like Vivian said earlier, would help to manage, that entire process. But in terms of the enforceability arrangement or structure, they'll be contained in the documents that I mentioned earlier, which is the security trust deed, as well as the intercreditor agreement, right? And they may contain provisions that give express power to the trustee to take legal proceedings or enforcement proceedings against the borrower, right? So, and this is why the trust, system or structure creates, an independent and balanced system. So this is a situation whereby even the trustee, right, the settlor would allow the trustee to proceed against it, to take legal action against it, so that they can enforce, the security or that has been created for the benefit of the lenders, right? Um, and typically, when the proceedings are done, right, the proceeds of the enforcement proceedings will be paid directly to the trustee, right? So it's out of the control of the borrower, right? And no lender will be allowed to receive proceeds directly, because the trustee has been appointed to manage, the entire process, and make the distributions, between the respective lenders, under the arrangement. Peradventure, a lender receives personally some of the proceeds, of the enforcement, that can be overturned, right? Because that defeats the essence, and the purpose for which a trust is being created. So these trust systems allows you to create transparency, and independence to ensure that parties can be enforced. So that's one. Secondly, is that, in some cases, right, the documentation can contain provisions, right, um, that allows the trustee to act based on the instructions, of a particular group of lenders, right? So in a multi-lender scenario, right, this typically will be, based on the majority instruction of the senior lenders, right? And in a situation whereby the senior lenders have been fully paid, right, you can also consider a situation whereby a majority of the subordinated lenders can also give instructions, right, to the trustee, right? And in some situations whereby, like I said, the multi-lender scenario, right, you could also have a situation whereby um, um, the agreements can give express powers to subordinated lenders under certain scenarios, right, to also be able to give instructions to the trustee. That'll be majority of the subordinated lenders. So this just shows that the documentation, the security documentation can be structured in such a way that will provide fairness, across board, right? You understand? But in most cases, the senior debts and senior lenders will be prioritized, right? But where need be, even subordinated lenders can have circumstances and situations whereby they could be able to instruct the the trustee, to enforce as well, right? So in summary is that the security documentation would contain those provisions, right? And that entire process is well managed, right, by the trustee, who has the power to even enforce, the security against the borrower.
Thank you very much, Adekunle. I mean, that really does explain the enforceability, and I mean that will bring a lot of reassurance for uh, prospective lenders. So I'd like to ask you another question. How does a debenture trust mitigate risks associated with multiple lenders having different levels of security interest in a borrower's assets? Because let me give an example. If lender A wants to be the first receiver in case there's a default and there's a liquidation. They might want to be the first, and then somebody, the financer B, will have another interest. How do you juggle this? How does a debenture trust mitigate this risk with having different levels of security interest in the borrower's assets?
All right, thank you very much. I mean, and that's the essence of a trust, right? That's what a trust does for you to create that independence, right? I mentioned earlier that in an enforcement scenario, the proceeds of the enforcement will be paid directly to the trustee, right? And the trustee will be responsible for managing the distribution, of the proceeds of the enforcement, right? So that shows that there is an independent party, right, that will, hold the process of the enforcement proceedings, for the benefit of all the lenders, right? And that's why doing the documentation, the security documentation, right, the rights and interests of the respective lenders have to be properly articulated, in those documents, so that you don't miss out, at the time that you need to enforce, right? So just to go back to my earlier point, those security documentation would provide um, the mechanism, for mitigating this risk, right? So, in relation to this, typically is the intercreditor agreement or the intercreditor deed that would outline or set out, the order of, usually you create a ranking or priority process for the various, liabilities, right? So the intercreditor deed or agreement should properly outline how this will be dealt with. So typically, for instance, is that the senior debts, the senior lenders would be prioritized, right? So they would take first. So that was typically, this would be the banks, right? Typically after that,
Sorry,
you look at the,
Adekunle, when you say the senior debtor, that means the person who advanced money first to the borrower, right?
no, 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 not necessarily, right? These
Okay.
are
So can
typically,
you throw a bit more light
typically
on that?
commercial banks. These typically
Okay.
are commercial banks.
Okay.
Yeah,
So
typically
even
commercial
if
banks.
a finance house, for example, first borrowed money to the borrower, are you saying the financing from a commercial bank will supersede that? Or
Let me just say
just like a
financial
bit more
institutions, not
clarity?
necessarily banks, right? So that would
Yes.
typically financial institutions, right?
Yes.
Including a finance house, right?
Okay.
And for a finance house, when you are dealing with the documentation, right, you should ensure that, um your credit, your facility advance to the borrower, is categorized or is ranked as a senior debt, right? So that when other financial institutions come in, you can now rank pari passu with them, right? So that means all of you will be paid together, right? In
Okay.
proportion to how you have provided or advanced a facility credit to the borrower,
To the
right?
borrower.
So you have to
Right.
ensure that you come in as a senior lender, right?
Okay.
After that level, are typically what they call the mezzanine debts, right? So these are usually bridge finances, right? That you take pending when you can get, um, a typical financial institution to support you for those things, right? So usually they would come next to those senior debts, right? Then after that would be the investor lenders, right? These are typically shareholder loans, right? Or the intercompany loans and the like. So, shareholders, equity are usually ranked riskier and lower, right, across, and the debts they provide usually come down the food chain, so to speak. So, so you have to negotiate the security documentation in such a way that you ensure that if you are required to be a senior debt provider, you are ranked as such, and you are ranked pari passu with respect to other senior lenders, right? Then you're able to mitigate the risk so that in an enforcement scenario, the trustee would deal with the proceeds of the enforcement in accordance with how the distributions have been outlined or the priority or rankings have been outlined, in the intercreditor deed agreements.
Thank you very much. I mean, that really does clarify the questions about ranking. Um, so while we move through the presentation, dear participants, I'd like to enjoin you to please feel free to use the Q&A feature to submit your questions. We'll have a dedicated Q&A session, that's question and answer session at the end, where we'll address as many of your questions as time allows. Your participation is important. We want this session to be as engaging as possible. Some questions are already popping in. Please continue. We're here to help make this session as valuable as possible for you, especially as you've taken your time to, to join this webinar. Okay, so Vivian, we would like to come back to you. I would like to know what are the common challenges faced by a security trustee in fulfilling their duties under a debenture trust agreement?
Thank you, Arians. So, at the initial stage of the structuring, like Mr. Shoibo mentioned, certain documents are put in place by the trustee, usually drafted by either an external solicitor or in-house lawyers in the trust firm. So, at this initial stage of structuring, these documents are tailored in such a way that anticipated issues are already addressed even in the present. So there are instances at the documentation stage, there are usually conflicting interest of lenders in agreeing to certain provisions of the draft transaction documents that have been circulated. So let me give a typical example. There are times that the category of acceptable assets to be used as security are not acceptable by all the lenders. So, in a situation where we have that interest or that conflicting interest, we either call an all parties meeting and let the lenders know that this is standard practice, this is industry practice, and all of that. So these conflicting interests come in at the initial stage. Then another example is where the respective lenders' risk appetite is different. So, what commercial bank A is comfortable with in terms of their credit and risk appetite as is in their system in-house would be different from what commercial B bank prefers. So these are also conflicting interests that we address at the initial stage and also ensure that we address even in the draft transaction documents before they are executed. Another example are voting rights and consent issues. So consent issue in such an example is where there's an existing trust, all of the transaction documents have been executed, and there's still room to provide or rather admit an additional lender. Some of the existing lenders become weary and are like, no, they're not comfortable with bringing in new lenders, which is at the end of the day forfeiting the whole objective of optimizing the value of the assets that are held under trust. So voting rights, consent issues. Another issue at the initial stage is also the order of priority. Like Mr. Shoibo mentioned, we always ensure that we anticipate whatever issue would come up in the nearest future. So the order of ranking would be clearly stated in the intercreditors agreement. So this way, if anything comes up in the nearest future, all the trustee needs to do is go back to his books, check what the provisions of the security trust deed or intercreditor trust deed provides. That way, they address the issues. Another example again is there are times that the borrower has some sort of top-notch relationship with a bank, but doesn't have that same relationship with another bank. So there are some banks that also leverage on the goodwill of the borrower. There are times that they don't even mind exceeding the value of the assets that are held on that trust. They would say, oh, we know that these people would repay the loan, would continue with the process of advancing the loan. Meanwhile, some other lenders are like, no, we don't have that in place. We don't have that sort of relationship in place. So what we are going to dwell on is the actual valuation of the asset. So these are some of the issues that we've experienced over the years in terms of managing transactions like this. There are times, another challenge again is there are situations where we find ourselves where the borrower submitted an overvalued asset. In addressing this issue, we have our own list of acceptable estate valuers that we work with. So we don't want to find ourselves in a situation where an asset is ordinarily valued at market price at say 100 million, but at the initial stage when it was submitted, what we received was 300 million, and then when it's time to enforce, we find out that it's actually not 300 million but 100 million. So this is another challenge that we've also experienced over the years. But in addressing these issues, we learn from existing transactions to ensure that in the nearest future for new transaction and even the existing ones, we are able to anticipate and address some of these issues. So these are some examples. These are some challenges that we face as trustees in multi-lending transactions.
Wow, these are very daunting challenges. But I trust that American Trustees Limited is well equipped to find means to surmount the challenges that you've just
Certainly,
listed. Yes,
certainly.
yes. So I'd also like to ask you, what are the procedures for handling defaults under a debenture trust? I mean, how does the
Okay.
security trustee ensure that the interests of all the lenders are protected, especially given all some of the challenges you listed just now? What are the procedures? How do you deal with that?
Okay, so there are several procedures that we've put in place, and we also try to incorporate into the transaction documents. So when I say transaction documents now, I mean the documents that Mr. Shebo mentioned earlier on, the intercreditors deed, the security trust deed, the debenture deed. So all of these are usually indicated or clearly stated in the transaction documents. So the major manner in which a trustee does this is to number one, monitor the lender's exposure from time to time. So at Meristem Trustees, what we've done is to ensure that we have a register of the lenders, also have a list of all of the secured assets. So we monitor their exposure as against the value of the assets from time to time. The trustee also, in line with the security documents, monitors compliance on the borrower's obligations to the lender. So beyond the transaction documents that we've mentioned earlier on, the borrower also has a separate loan agreement or facility letter or offer letter, as the case may be, between the bank, and that's the lender, and the borrower. So we also monitor the entire process of ensuring that the borrower actually complies with the provisions of the loan agreement. Another process is of handling defaults. As soon as the trustee is aware that there is some sort of event of default, it immediately informs all the lenders. It usually would outline the nature of the default and also explain in detail what the potential impact of this default would have on the trust and on the lender's interest. So after notifying the lenders, what we do is we review sometimes before we notify and after we notify, we review the transaction documents again, which is what we've already executed at the initial stage, and we are able to determine the available remedies to resolve these defaults. So some of such remedies are enforcement of the security. So like Mr. Shebo mentioned earlier on, in enforcing the security, we use the for sale value of the assets, and we sell them, and then proceeds from the sale of the security that were held under trust would then be distributed in line with the provisions of the trust document. So usually based off the ranking of the lenders. There are times that beyond, before we get to that step, there's usually a grace period sometimes that where we don't enforce immediately, either because we know that this borrower has some sort of credit worthiness. So there are times that we renegotiate the existing terms between the borrower and the lender. In a case where the security is enforced, the trustee always is expected, like we mentioned earlier on, to distribute the proceeds in line with the order of priority of lenders. So these are the ways that we look out for the interest of the lenders. And all of these are always at the initial stage, clearly tailored and stated explicitly how this would be gone about in the transaction documents. The security trust deed, the intercreditors agreement, the mortgage deed, whatever documents have been put in place, will clearly state all of this.
I mean, this clearly shows that it's important at the very beginning, at the setting of the trust, that these measures are put in place.
Yes, it's also very important to mention that in all of this, the trustee ensures that there's transparency and fairness at all times. So we cannot favor lender A and
Over lender
disrupt
B.
the interest of lender B. So in all of this, in our communication, we are communicating to all of them at the same time. We are giving updates. There's transparency, there's fairness. That's the whole objective of a trust at the end of the day, anyways.
Very, very informative. Thank you very much, Vivian. Thank you very much. We have a poll going on. We have an ongoing poll, and we would like you participants to please participate in this poll. The question here is, I'll just read it out to you. We just want to know if you currently do business whilst leveraging on working capital. Would like you to answer is a yes, is a no, or a maybe. And then would you be interested in a one-on-one consultation with Meristem Trustees Limited to discuss optimizing the value of your assets to secure borrowings? So, you may have a lot more questions. Come inbox, message us. We'll try to answer your questions as much as we can. Okay, so I'd like to come back to you now, Adekunle. In cases where the borrower enters insolvency, how does the debenture trust coordinate with other stakeholders, such as the liquidators, the administrators, and other creditors? How does the trustee coordinate all of this?
Okay, so in a situation of insolvency, right? Maybe most times, maybe the lenders may know first, right? And they may reach out to the trustee, right? If documentation provides for the borrower to provide their financials to the trustee, right? And at that point in time, the trustee may be able to determine whether there's a likely situation of insolvency. So because the trustee is independent, right? What we would typically, provide, advice is to look at the situation, with the lenders and see whether there are other ways to resolve, the potential insolvency, right? And that could include doing some loan workouts and the likes, right? Just so that it can give the borrower some breathing space to be able to pay off, those loans before everything goes into insolvency. So that would require some, negotiation, and engagement between the borrower and the lenders, right? And the trustee could, mediate, that entire process itself, right, before it gets into an insolvency situation, right, or an enforcement situation. Because many times, people these days tend to think corporate rescue, right, more than just enforcement or receivership, of the borrower. So, but peradventure, that doesn't work out and it gets into a situation of insolvency. A receiver or receiver manager has to be appointed, to manage the affairs of the borrower, right? So in that situation, that receiver takes the position of the settlor, right? And the trustee is still, responsible right, for the benefit of the lenders as well, right? So the trustee will continue its role as a trustee, right? But will now take instructions from the receiver, right, to be able to manage the entire assets. So in that situation, right, the interests of both the borrower and the lenders are still, adequately secured. In addition, the security documents could also provide other steps that has to be taken, right, to ensure that that entire process sails through, right, and does not and is not hampered in any particular way. But like I said, I think the best situation is to ensure that you don't get to a situation whereby you have to engage a receiver or receiver manager, or you have to enforce the security. If those loan workouts can be done, right, to ensure that the borrower is still able to pay. Practically, when looking at their financials, they are still in a position, to adjust some things and be able to pay. The entire stakeholders within that security trust arrangement, stands to benefit more from that situation, so that they can all get back their returns, or whatever they're due to based on the facility arrangement they have, right, before everything gets into an insolvency situation. But, because it's a trust situation, the trustee can also manage that entire process, on behalf of both the lenders, and the borrower as well. And even when a receiver or receiver manager is appointed, right, the trustee still continues to play that role, right, for the benefit of the lenders and the borrower as well.
Thank you very much, Adekunle. Thank you very much for that answer. Okay, I would like to come back to you, Vivian. You talked about the challenges, one of the questions, the common challenges faced by security trustees. Now, I'd like to ask, so in cases where these lenders have conflicting interests, financier A wants this, which conflicts with what financier B has, how does the security trustee, how will a Meristem trustees prioritize their obligations? How do you ensure that each party's interests are prioritized?
Okay, thank you, Aaron. So, as mentioned earlier, a trustee plays a crucial role in balancing the conflicting interest of multiple lenders in transactions of this nature. So, remember that we had mentioned that transactions like this are always governed by legal frameworks and legal documents, trust documents, and all of that. So the trustee in addressing any conflicting issue must at all times adhere to the provisions of the what's it called, the transaction documents and the legal provisions of the statutes and all of that. The trustee at all times must follow the instructions of the majority lender. Mr. Shaibo mentioned earlier on that the majority lender is always, clearly defined in the transaction documents. The order of priority is also always defined in the transaction documents. The trustee cannot on its own. So yes, the trustee is acting as an independent party, but it is also guided by the provisions of these documents that have been executed between itself, the lenders, and the borrower. The trustee cannot go outside of the provisions of these documents. So, if, for instance, the transaction document says that the trustee should follow the instruction of majority lender, then the trustee has to go by way of the instruction of majority lender. So, the trustee, yes, is trying to balance and manage the situation, manage the relationships, and all of that. But once there are clear conflicting interests, it cannot go outside of the provisions of the transaction documents. That's why I mentioned earlier on as well that because we anticipate that some of these loans may go bad, we ensure that we see the future and ensure that the current documentation stage actually addresses the anticipated issues that we think we might experience. So we go back to the books, we review, and we adhere to the provisions of the trust deed.
Thank you very much for that answer, Vivian. We've come very far in this webinar today. Just a few more questions to go before we get to our Q&A session. So, Vivian, could you just very briefly outline the process of appointing a security trustee in a multi-lender debenture trust structure?
Okay, so the formal appointment of a trustee is usually ratified by the lenders. So there are times that the trustee would have to make a direct pitch to the borrower, but at the end of the day, the lenders would not approve the appointment of the trustee where they believe that the trustee does not have the experience, the wealth of experience to manage transactions of this nature. So most times, more often than not, the first point of contact is always between the borrower and the lender. And there are other situations where the lender is aware that the borrower has quite a valuable size of assets and knows that they would not be able to, give them all of the amounts or borrowings that they require. So they might also advise the borrower to, engage a trustee and get all of the assets put together under the trust, whilst they give them a portion of the loan that they require and speak to some other lenders. So usually the appointment is always, the letter of appointment is always between the trustee and the borrower, but the lenders must ratify the appointment of the trustee. This is why the intercreditors agreement that we mentioned earlier on is usually between all of the lenders and the trustee. So in these documents, some of the provisions are the lenders confirming that they are okay and fine with appointing, for an example, Meristem Trustees Limited. So the lenders would usually look out for the trustees' reputation, the trustees' experience, also ensure that the trustee is actually licensed to carry out this duty. And the next the next is structuring the trust in place. So after the appointment, all of the assets that the borrower seeks to secure his borrowings would be transferred to the trustee. So now I don't mean physical transfer. So the legal transfer of these assets will be moved to the trustee. In doing this, the trustee would place a charge on either the borrower's floating assets or fixed assets. So these are some of the it could get a bit technical when we get to that stage of putting the actual structure in place. But this is like an insight into how a trustee is appointed for transactions like this.
Thank you very much, Vivian. I'm sure if our listeners have questions on how to go about it, they can always reach out to
Yes,
any of our
definitely.
contact persons at Meristem Trustees. I will be very, very happy to walk you through. We're happy to hold your hands and walk you through the entire process of starting to finish. I have just one more question for you, Adekunle. Um, what trends do you foresee, in the use of debenture trusts in structured finance over the next few years? Because it's not a very popular thing right now. The awareness is just growing, but as time is going, what is the trend you foresee in the use of debenture trusts?
Okay, so thanks, Aaron, for that question. So in terms of trends, I think I can picture two sort of trends. And
Okay.
one is in relation to technology, right? Which is also helping to accelerate the process of registration of all these interests that are required, in the security trust itself. So
Okay. Interesting.
if you are familiar with this terrain, you realize that with the Corporate Affairs Commission, there are a couple of things they've done in relation to ensuring that you can register these things, from the comfort of your office, right? Before you would need to send across a physical document to be able to register the relevant security document at the CAC. But today, those documents can be uploaded into their platform, right? And you get a response electronically as well, right? You get the approvals electronically as well, right? So technology, is improving, and accelerating the ability to get these things done quicker and much easily. And a firm like Meristem as well, there is adopting technology on their several products, right? Which I'm going to say I'm projecting that, some of this ability to register these things, will be linked from, the maybe websites, platforms created by a Mersem trustee to make, registration, and creation of this security interest much quicker, and easier. So in terms of timeline, before it would take you 4 to 6 weeks to register, a security with the CAC, but now you can do it in 1 week, right? And with more technology, you probably can do it in 1 day, right? So these things are likely to become a lot more easier to do, right? And that goes to the benefit of, our participants here who want to take advantage of the opportunity that Debenture Trust offers. The second I'm saying is, in terms of asset classes, right, that you can use as security. So I think, there are more inquiries from my own side. We're seeing more inquiries around the use of virtual assets, right? Virtual tokens and other forms of intangible assets to be able to do this. So this shows that we as professionals have to be more creative, right? And as this asset becomes more accepted, right? We need to also engage regulators to ensure that, we can certify and ascertain, right, the value of these assets, and they can be used as security, for similar security trust arrangements that we may want to enter into. So I foresee the ability to use, more assets, more class of assets than we're used to, right? As the terrain becomes more developed and the virtual space or virtual assets, begin to increase. So those are the two areas I see. One is tech, and one is expansion of the asset classes that can be used as security interest.
Thank you very much, Adekunle. So this leads me into uh, one of the questions that the participants have been asking. So we have a message from Olusegun Adebayo. Thank you very much for joining us, Olusegun. I hope you found this webinar informative. Your question on categories of assets. So Vivian, please, I'd like you to take this question. So Olusegun wants to know, what are the categories of assets that we're talking about? And do we have specific locations for these assets? So, for example, in case of landed properties. So please, could you shed some light on this, Vivian?
All right, thank you very much, Arians, and thank you, Lufemi, for the question. So, typically, the assets that are pulled into the trust, the assets that are secured under the trust are usually real estate, plants and machineries, especially for those companies that are into manufacturing and all of that. There are times, there are situations that lenders are actually also comfortable with using stocks. So in putting all of this in place, the trustee would usually ensure that evaluation exercise is carried out at inception of setting up the trust and also on a periodic basis. This is to ensure that it covers the lender's exposure from time to time. So in terms of location, because of how Nigeria is wired, we usually sometimes shy away from accepting certain assets, especially when it comes to real estate. So, say for instance, the property is located in an area that is always having some sort of community issue or whatnot, an area that is not easily accessible to us. So beyond placing the charge on the assets, we also do our own independent periodic visits. We don't want to find ourselves in a situation where it's time to enforce and we cannot easily enforce to satisfy the needs or requirements of the lenders. So we shy away from accepting certain real estate assets located in areas that are not very easily accessible. But at the end of the day, we have no choice if the lenders say they are fine with it. So say for instance, a lender says they are fine with a property in Sambisa, we have no choice, we'd accept it. So far, we've accepted to act as trustees on that transaction. So the typical assets are usually real estate, plants and machineries. There are also situations where restructure and all assets debenture. So in an all assets debenture, everything that the borrower owns goes under trust, including its laptops, vehicles, everything it owns, everything in its building fixtures, everything goes. Fixed floating assets go into the trust. So these are the sort of assets that are acceptable. Most times
Thank
the
you.
lenders must confirm that they are fine with it before we
Okay.
proceed with the structuring.
Thank you. Thank you, Vivian. So we also had a similar question from Adora Wanzota. I hope I got the pronunciation of your name correctly. I hope the answer by Vivian addresses your question, because she also asked what's the limitation to the type of assets that can be leveraged and placed in trust, whether they were cash, securities, and real estate. So, Adora, I hope that Vivian's answers have addressed your question. So we have a lot more questions, but unfortunately, we're running out of time. So I'll take one more question from the chat. Is by an anonymous attendee. We would love to know who you are. So if it's possible for you to send us your name and your contact, we can reach out to you. He or she wanted to know if the debentures is an investment option or a form of collateral to secure a business loan using existing business assets. So very quickly, Vivian, can you just clarify
Yes,
that?
so
Yeah,
yes, it's
thank you.
basically a form of collateral to secure borrowings, to secure loans. So in terms of investment, so if you're an investor that is aware that a borrower is looking to raise capital and you're comfortable with a trust arrangement, you can actually advance the capital to the borrower whilst leveraging on the trust structure that has been put in place. But the debenture trust simply is the assets that have been transferred into the custody and ownership of the trustee to secure borrowings from the
Thank you.
borrower.
Thank you very, very much for that, Vivian. Thank you very much for that. Would like you to all continue to send your questions in. We have Rex who will attend to your questions and will respond to the rest of your question. So I'd like to also provide you our contact details for further inquiries. You can contact us at trustees@meristemng.com, and you can also reach us on 070-256-40071. These details will be displayed on the screen. So our technical guys will display these details on the screen. So we've come to we've almost come to the end of our webinar today. However, we'd like to have a round-off address by Abiola Ayoyinka Ube. She's the head of business development at Meristem Trustees Limited. Please join me in welcoming Abiola. Abiola, you're welcome. The floor is yours.
Good day, ladies and gentlemen. It has been an insightful and enriching experience today as we delved into the topic, optimizing your assets for business growth. I would like to extend my gratitude to my esteemed speakers for sharing their practical insights and also their thoughts on how we could maximize our assets to ensure business growth. And I would also like to extend my appreciation to our participants for their time, for their attention, for making today a success. Your comments and your questions are well noted, and we appreciate all of your comments. And I would also appreciate our organizing team for making this a success, for ensuring the smoothness of the webinar. Thank you, everyone. In conclusion, I hope today's session will bring new ideas and a renewed focus for optimizing our assets for business growth. And I would like you to put into practice all the strategies that our speakers have spoken about to ensure sustainability of business growth. Thank you for joining us today. We appreciate your attendance. We appreciate your participation, and have a good day.
Thank you, everyone. Please continue to send in your questions, continue to engage with us, and do have a wonderful week, a wonderful day, and the rest of the week ahead.
From taking their first breath, saying their first words, to taking their first steps, life is a journey. The journey from using a pencil to a pen, from kindergarten to college, and from chalkboard to boardroom. At Meristem, we can make that journey easy for you with our Meristem Education Trust, which allows you to set up a dedicated trust account for your children's education. With our Meristem Education Trust, you can rest assured knowing that neither death nor incapacitation can hamper your children's education. To get started, kindly call us on 0700 Meristem or send us an email at trustees@meristemng.com.
The fear of the future and its uncertainties puts a lot of pressure on people. Pressure of safeguarding their assets and caring for their loved ones. What happens to your hard-earned assets in your absence? How do you protect your loved ones from extended family wahala when you're gone? I'm sure you've considered writing a will, but you're reluctant because you think it's a complex process. Well, did you know that in the time it took me to make this coffee, you can write a will? Sounds unbelievable, right? Yet very possible. We believe that nothing should hinder you from living a good life behind for those you love most. With Meristem Simple Will, you can write a will that protects your assets and provides for your loved ones from the comfort of your home. All you need is an internet-enabled device. To get started, visit meristemtrustees.com/simple-will. At Meristem Trustees Limited, we are committed to ensuring your legacy lives on.
The beauty of wealth lies in growing, preserving, and transferring it. Building wealth isn't only what you do for yourself, it's what you do for generations to come. And to pull that off, you need partners. Partners who understand that the assignment isn't just to grow your wealth, but to preserve it against the harsh storms of life and ensure it sees the light of day, ready to be transferred from generation to generation. So you see, the art of building wealth is all about growth, preservation, and transfer. And at Meristem, we have perfected that art.
Meristem, let's grow wealth for you.
The only way to move, face up, the way to go, the top, you've come this far.
Your story doesn't have to end with you. As a matter of fact, it can continue into the next generation and the generation after that. After all, you've worked hard to get to where you are. Why should your wealth end with you? Let your story continue.
Meristem, let's grow wealth for you.
From taking their first breath, saying their first words, to taking their first steps, life is a journey. The journey from using a pencil to a pen, from kindergarten to college, and from chalkboard to boardroom. At Meristem, we can make that journey easy for you with our Meristem Education Trust, which allows you to set up a dedicated trust account for your children's education. With our Meristem Education Trust, you can rest assured knowing that neither death nor incapacitation can hamper your children's education. To get started, kindly call us on 0700 Meristem or send us an email at trustees@meristemng.com.
The fear of the future and its uncertainties puts a lot of pressure on people. Pressure of safeguarding their assets and caring for their loved ones. What happens to your hard-earned assets in your absence? How do you protect your loved ones from extended family wahala when you're gone? I'm sure you've considered writing a will, but you're reluctant because you think it's a complex process. Well, did you know that in the time it took me to make this coffee, you can write a will? Sounds unbelievable, right? Yet very possible. We believe that nothing should hinder you from living a good life behind for those you love most. With Meristem's Simple Will, you can write a will that protects your assets and provides for your loved ones from the comfort of your home. All you need is an internet-enabled device. To get started, visit meristemtrustees.com/simple-will. At Meristem Trustees Limited, we are committed to ensuring your legacy lives on.
The beauty of wealth lies in growing, preserving, and transferring it. Building wealth isn't only what you do for yourself, it's what you do for generations to come. And to pull that off, you need partners. Partners who understand that the assignment isn't just to grow your wealth, but to preserve it against the harsh storms of life and ensure it sees the light of day, ready to be transferred from generation to generation. So you see, the art of building wealth is all about growth, preservation, and transfer. And at Meristem, we have perfected that art.
Meristem, let's grow wealth for you.
The only way to move, fish up, the way to go, the top, you've come this far.
Your story doesn't have to end with you. As a matter of fact, it can continue into the next generation and the generation after that. After all, you've worked hard to get to where you are. Why should your wealth end with you? Let your story continue.
Meristem, let's grow wealth for you.
From taking their first breath, saying their first words, to taking their first steps, life is a journey. The journey from using a pencil to a pen to college, and from chalkboard to